All right, so in this module, we're going to talk about one of the most foundational topics in legal research and legal analysis, and that's understanding how courts are structured in the United States. So at first, students sometimes just assume that, the court structure is just some procedural information that they need to memorize for a quiz, right? But honestly, understanding the court systems and the fact that they affect every area of legal practice is very important. Court structure determines where lawsuits are filed, which judges have authority to hear disputes, what law is going to control how appeals work, and what precedent becomes binding. So you can't properly research law if you don't understand the court system itself. What court specifically is issuing the authority that you're reading, okay? And honestly, one of the biggest mistakes that beginning researchers make is treating every court opinion like it carries the same kind of weight, and it does not. All right, so a United States Supreme Court, like constitutional opinion, is going to carry dramatically different authority than, say, a local trial court decision from another jurisdiction. Okay, so understanding hierarchy changes how legal professionals evaluate every source that they read. So, Actually, let me back up. So another thing that students often misunderstand is assuming that the United States has like a single unified court system. And we actually operate under overlapping systems. So there's a federal court system, and then every state also maintains its own court structure. So those systems interact constantly, but they're not identical. So the structure exists because of federalism, which intentionally divides the governmental power between the states and the federal government. And again, the framers of the Constitution were very deeply concerned about concentrating too much authority into a single national government, so that power was intentionally distributed. So that means that the legal authority often depends heavily on where a dispute arises and what kind of issue is actually involved. For example, let's say family law. It's usually handled primarily through state courts. You've got divorce, child custody, probate, adoption. All those matters are generally state law issues, right? But constitutional claims, federal criminal prosecutions, bankruptcy, immigration, patent or trademark litigation, all of those involve federal courts much more directly. Now, this layered structure is one reason that people do become frustrated with legal issues. And that's because they want simple universal answers. They want someone to basically say, this is the law everywhere, right? But American law does not operate like that. Different states can interpret issues differently, so federal courts can disagree with each other. Procedural rules are going to vary between jurisdictions, and understanding where authority comes from becomes just as important as understanding the rule itself. So that's why this chapter matters so much. Before researchers can evaluate precedent, before they can interpret statutes or analyze constitutional questions, they first need to understand the structure of the court systems themselves. Now, one of the defining characteristics of our legal system is federalism, which again is that division of power between the federal government and the states. Now, honestly, federalism is one of the biggest reasons that legal analysis can feel very complicated initially, right? Because students do often want very straightforward answers to legal questions, but the answer is frequently, and if you're going to go to law school, get used to this, it depends. All right. A lot of that depends on whether it's state law or is it federal law, or are they both involved? The Constitution created this system where certain powers belong primarily to the federal government, while other powers remain primarily to the states. Okay. There is some overlapping authority, though. You even have some authority that conflicts with the other. You have some authority that changes over time through constitutional interpretation. Again, this layered structure is very intentional. The framers, they had a fear of this centralized governmental power, so they designed a system balancing national authority with state sovereignty. So that's why states can differ dramatically in certain legal areas. So, for example, States can have very different approaches involving things like gun regulation or criminal sentencing or education, voting, healthcare, marijuana. That's a good one. Like, imagine somebody says, well, marijuana is legal. The immediate legal response should be, where? Where is it legal? Because legality may differ depending on, again, federal law, state statutes. You even have local local ordinances, and then, any kind of enforcement priorities that exist. And that complexity right there is what reflects federalism in action. The other thing I wanted to say is that you should also understand that federalism creates, again, this overlapping legal system that's operating simultaneously, okay? So, for example, an assault is usually prosecuted under state criminal law, right? But if that assault occurs on federal property or against a federal officer or in connection with some sort of federal criminal activity, then suddenly federal jurisdiction can also exist, all right? Same thing with like employment discrimination disputes. They can involve, federal civil rights statutes, state anti-discrimination laws. You have administrative regulations and even constitutional concerns, and this can all happen all at once, right? So that overlap becomes important in legal research because researchers have to constantly identify which law is going to control, which court has authority, what precedent governs. And honestly, this is why legal professionals become very careful with broad statements. That's why we use it depends. And the law is rarely as simple as internet arguments like to make it sound, right? People online love to go, that's illegal, or they can't do that, or that violates the Constitution, right? Real legal analysis requires much deeper evaluation that looks at jurisdiction, and authority and precedent and procedural rules and even factual context. All right. So one of the reasons that federalism matters so much is because it does allow the states to function somewhat like policy labs, right? Different states are experimenting with different approaches, involving things like your criminal justice reform or healthcare regulations or, education policy, voting laws, things like that. And sometimes those experiments tend to influence national trends later. All right. But federalism, again, it's going to create both this complexity and kind of flexibility. And understanding that balance is going to become essential later on when analyzing constitutional law and jurisdiction and judicial authority. One of the most important legal concepts in all of legal procedure is jurisdiction. And it simply means the authority for a court to hear a case and decide a case, right? Students often underestimate how powerful this concept is because they assume that courts can hear, essentially any dispute that someone files, and it's not true. Courts possess, or they have to possess the legal authority before they can act. And if jurisdiction is missing, then the case may fail before any of the substantive issues are even ever heard. Okay? Now, there are a few different forms of jurisdictions that you have to understand. One of the most important is subject matter jurisdiction. And that refers to the court's authority over the type of dispute involved. So, for example, bankruptcy courts hear bankruptcy matters. Probate courts handle, very specific, like estate administration. A family court is going to address divorce and custody. Federal courts are going to hear, federal questions and constitutional questions. If a court lacks subject matter jurisdiction, it generally cannot hear the dispute at all. All right. So subject matter jurisdiction becomes incredibly important because parties usually cannot simply agree to ignore it, right? A court either possesses the authority or it does not, period. Another major category is personal jurisdiction, which is going to refer to the court's authority over the individuals or the entities that are involved in the lawsuit, right? So imagine that someone is living entirely in Georgia and they get sued in California over conduct that occurred exclusively in Georgia with no meaningful connection whatsoever to California, right? Well, immediately questions are going to arise involving the fairness and the constitutional authority. Can California legitimately exercise power over that defendant, right? So those questions become even more complicated today when you start factoring in things like businesses and individuals interacting across state lines constantly through things like e-commerce and social media and remote work and, just general online communication, right? Another important concept is territorial jurisdiction, which concerns the geographic boundaries and like where the legal authority applies, physically speaking. Okay. So one thing that students sometimes fail to appreciate is that jurisdiction is not merely like procedural paperwork. All right. It does reflect constitutional principles that involve fairness and governmental power and due process. So that's why attorneys like to analyze jurisdiction immediately when evaluating litigation. Because imagine spending months and months litigating only, to discover that the court lacked the authority to begin with, right? That creates delay and expense, and you have like procedural chaos, and for it all to get potentially dismissed, it's a mess, right? The other thing that you should understand is that jurisdiction can become extremely strategic. So attorneys can aggressively argue about like where a case belongs, which court is more favorable, what procedural rules apply, what jury pool can hear the dispute, things like that, right? This is called forum selection, and forum selection can very significantly influence litigation outcomes. Honestly, one of the reasons that legal work often resembles kind of a strategic chess match is because of this. Because it's more than just simply, applying rules, mechanically speaking. Again, researchers and litigators are going to constantly have to evaluate authority and procedure and jurisdiction and timing and strategy, all these things simultaneously. So now that we understand jurisdiction, kind of generally speaking, let's talk about when federal courts specifically are allowed to hear cases, okay? And this is where students often realize that federal courts are much more limited than they probably originally assumed, all right? Because federal courts are courts of limited jurisdiction. That means that they can hear only certain categories of cases that are specifically authorized by, the Constitution or the federal statutes and even like congressional jurisdictional rules, all right? And this differs very significantly from a lot of state courts, which are often courts of general jurisdiction, and they hear a much more broad range of disputes. Now, one of the most important categories bringing cases into federal court are the federal question jurisdictions. These exist when a case comes up under the Constitution or federal statutes or treaties, something like that, right? So lawsuits that involve like constitutional rights, patent law, discrimination statutes, civil rights violations, copyright, federal criminal charges, all of those things involve federal question jurisdiction, all right? So if someone, say, sues a police officer over a violation of the Fourth Amendment protections during a search, constitutional interpretation immediately becomes central to the dispute, creating a federal question. All right. Now, another major basis for federal jurisdiction is diversity jurisdiction. And this is one that a lot of people kind of struggle with because it focuses heavily on citizenship. Now, diversity jurisdiction allows federal courts to hear certain civil disputes involving citizens of different states. All right. Now, historically, Congress worried that out-of-state litigants might fear local bias in state courts. So federal courts became available as supposedly like neutral forums, right? So imagine a Georgia resident suing a corporation that's headquartered in California. Well, diversity jurisdiction can exist if the statutory requirements are satisfied, right? And often, sometimes, well, let me take that back. Sometimes students will oversimplify diversity jurisdiction and assume any disagreement between people from different states automatically belongs in federal court. And that's not true. All right. There are additional requirements that exist. But remember, we're starting with, we have to have citizenship and complete diversity plus an amount in controversy threshold. Okay. So determining citizenship can kind of become complicated because residency is not always identical to citizenship. So like corporation, hold on. I'm so sorry. Residency is not always identical to citizenship, legally speaking. So corporations can possess multiple citizenship locations, and businesses can involve like layered ownership structures, right? So jurisdictional analysis often becomes very extremely technical. Now, another thing that you should understand is that attorneys strategically evaluate whether federal court or state court can be more advantageous. So some attorneys prefer federal court because procedures are often viewed as more structured and more uniform and sometimes even more predictable. But others, may prefer state court depending on, the jury pool, local procedures, scheduling, like judicial philosophy, substantive law advantages, all of those things. So this is why forum selection becomes part of litigation strategy rather than just, merely an administrative procedure. All right, so now let's talk about removal and remand, because these concepts, they demonstrate how cases sometimes move between state and federal court systems after litigation has already begun. Sometimes students will find it confusing because they assume that once a lawsuit is filed, it just simply stays there in that particular court. And that's not necessarily the case. Removal occurs when a defendant transfers a case from state court into federal court. And one thing you should notice immediately is that removal is generally initiated by the defendant and not the plaintiff. But why is that? And it's because the plaintiff has already selected the original forum when they filed the lawsuit, right? So imagine that someone files it in a state court, but it involves a federal employment discrimination claim, which is under federal law, right? So even though the plaintiff chose state court initially, the defendant can have the case removed into federal court because of that federal question jurisdiction existing, right? In the same, vein, diversity jurisdiction can also permit that removal under certain circumstances, which, by the way, I forgot to say last time, is that, the whole amount in controversy thing, the amount that has to exist for diversity to also exist is the case has to have $75,000 and 1 penny or more in order for it to be met. So that's just an FYI. Now, attorneys do care a lot about forum selection because different courts create different strategic advantages or disadvantages, right? So one side might believe that a local jury is going to be more favorable, and, maybe the state procedures are more advantageous. Federal judges might interpret, claims differently. Scheduling could also be an issue because one might move faster in one system than the other, right? So those strategic considerations matter a lot in litigation. Now, remand is essentially the reverse process, okay? So remand occurs when a federal court sends a case back to state court. And that usually happens because federal jurisdiction never properly existed, right? Or maybe the removal procedures that they used were defective. Or subject matter jurisdiction was lacking completely, right? So imagine that you have a defendant who removes a case claiming diversity jurisdiction, but it later becomes very clear that maybe both parties are citizens of the same state, or the amount in controversy fails, right? federal jurisdiction is going to fail and the case has to be remanded. Jurisdictional mistakes can become incredibly expensive, right? So you can have it to where you're litigating in federal court for like months before discovering that jurisdiction might have been improper from the beginning. That can create, delay and additional costs and a lot of strategic damage, in all honesty. So that's why legal professionals evaluate jurisdiction immediately when analyzing litigation. One other thing that you should understand is that removal law is interpreted very carefully because federalism principles matter here too. Okay, so federal court cannot simply absorb any case that they want. The legal system intentionally preserves the separate state judicial authority. So sorry, my dog is knocking things over. And honestly, one reason that removal becomes strategically important is because federal and state courts sometimes feel culturally different in practice. Like federal court often operates with, more strict procedural expectations and tighter scheduling and more formalized rules, whereas state court procedures are going to vary significantly depending on, the jurisdiction and the judicial philosophy, local practices, available resources, things like that. So understanding those practical differences become an important part of litigation strategy. Now, concurrent jurisdiction shows how state and federal authority can overlap. And this exists when more than one court system has authority to hear the same case. So that means that plaintiffs may sometimes choose whether to file in state or federal court. And that choice becomes extremely strategic. Okay, so imagine an employee experiences workplace discrimination. So that conduct can violate federal civil rights statutes, but also it can violate the state anti-discrimination laws simultaneously. All right, so as a result of that, both the federal and state courts can now potentially hear the dispute. Now, I know you might be thinking, if both courts can hear the case, is the choice... It doesn't probably matter, but it does matter, or it can matter. I don't want to say, we're going to stick with vague language. It can matter, okay? So different court systems differ regarding things like procedural rules, scheduling, jury pools, discovery practices, judicial tendencies, motion standards, all of those things, right? So attorneys are constantly evaluating those things, strategically speaking. You might have a forum where a case is going to move faster, or another can, provide for more broad discovery. Another might have a judge who historically interprets, certain claims more favorably, right? This all becomes a part of litigation planning. So just remember, concurrent jurisdiction, it really reflects federalism itself, because both state and federal courts, or governments rather, again, they can possess legitimate interest in resolving certain disputes, like employment discrimination, like constitutional claims. You might have environmental disputes, or like a consumer protection issue, again, that might overlap between state and federal simultaneously. All right, police misconduct. You might have potential claims in a police misconduct case that's federal constitution violations, but then also negligence or assault or battery or, other state tort claims. Again, suddenly we have multiple legal frameworks that are overlapping inside of the same litigation. All right. And that's one reason why legal practice often feels kind of procedurally overwhelming initially. So as a researcher, you're going to have to constantly analyze which claims exist, which courts possess authority, whether removal is possible, what law governs and what precedent controls. And that layered analysis is going to become incredibly important for your job, because procedural mistakes involving, jurisdiction can do some very, very serious damage to litigation. The other thing I was going to say, hang on, I got to think. Oh, I know what it is. This is a reason why legal work often feels strategic rather than just mechanical because it involves that substantive legal analysis along with, that procedural positioning at the same time. Now, exclusive jurisdiction is where we start seeing the limits of concurrent authority. All right. So exclusive jurisdiction means that certain type of cases can only be heard in one court system. All right. And that usually happens because lawmakers believe that certain areas require national consistency or some sort of specialized expertise. Right. One major example, copyright law. Right? So if every state maintained completely different copyright standards, involving, say, music and film and all of that, the entertainment industry would become chaotic almost immediately. All right? You would have creators and companies like operating nationally that would struggle constantly with the conflicting standards across the state lines. So copyright disputes generally fall under exclusive federal jurisdiction. All right. Patent work, same thing. Congress wanted consistent national standards involving inventions, intellectual property protection, technological innovation, right? Bankruptcy is another major example. Imagine if debt restructuring and bankruptcy procedures differed, dramatically from state to state. Then national lending systems would become incredibly unstable. Right? So if bankruptcy matters are handled federally, it makes the most sense, right? And I know you might be thinking, like, why are some issues exclusive while some others, remain concurrent? And a lot of that comes down to congressional judgment and constitutional structure, because some issues are viewed as requiring uniformity and that federal oversight and even that centralized expertise. When it comes to exclusive jurisdiction, again, it doesn't entirely eliminate state law. That's because you can still have, say, for example, go back to the federal copyright dispute, right? It can still involve contract issues and tort claims and damage questions and even business disputes that are shaped by, state law principles. Also, you can have state copyright laws. But again, these legal systems overlap constantly, and that overlap is one reason that legal research, again, becomes very layered rather than linear. All right, you're going to have to constantly kind of move between, statutes here, statutes there, precedents, procedural rules, what it looks like in the different places, and then even multiple sources of authority, kind of simultaneously. Another important thing about exclusive jurisdiction is that specialized federal courts often, develop this exclusive expertise, right, in these highly technical subject areas. So like patent litigation, for example. This can involve, like software systems, scientific evidence, engineering concepts, highly technical testimony, things like that. And that specialization is going to shape the litigation strategy and the legal research methods. Okay. And that's another reason that procedural knowledge matters so much in legal practice. So understanding the substantive law is going to mean very, very little if a case is filed in the wrong court or jurisdictional requirements are ignored. So now we need to talk about important constitutional limitations on federal power. And that is where federal courts are limited to actual cases and controversies. All right. This principle frustrates people because courts occasionally refuse to answer major legal questions that the public desperately wants resolved, right? And I know you might be wondering, if an issue is so important, why can't the courts just decide it? And the bottom line is that federal courts are just not designed to function as like general advisory boards, so to speak, right? They exist to resolve real disputes involving actual parties and very concrete injuries, right? So this limitation comes from Article 3 of the Constitution. Now, one major doctrine connected to this principle is standing. And standing means that a plaintiff generally has to show, they have to show personal injury, threatened harm, some sort of direct impact, right? People usually cannot sue simply because they agree with a law politically or philosophically, right? So imagine someone saying, well, I think this law is unconstitutional. That alone is not sufficient, right? That plaintiff generally has to demonstrate some sort of actual connection to the alleged harm. Now, another important doctrine to talk about here is mootness, okay? So a case becomes moot when a controversy effectively disappears before litigation finishes, all right? So if you have, say, a challenge to let's say a student, like there's a challenge to a temporary school suspension, but they graduate before the lawsuit finishes. Well, that dispute no longer presents an active controversy that requires any sort of judicial resolution, right? And federal courts generally avoid deciding moot issues because there's no longer a live dispute between the parties. You also need to understand advisory opinions. So federal courts generally do not issue advisory opinions answering like hypothetical legal issues that are disconnected from a real dispute. Even government officials cannot simply like ask the Supreme Court, like, would this policy be constitutional if we implemented it, right? Courts require actual litigation involving real parties. And these doctrines, they become incredibly important, strategically speaking, because attorneys often structure lawsuits carefully to ensure that we have standing that exists, that they're going to remain active and not go to, be moot, and that those jurisdictional requirements are also met. But if those procedural foundations end up failing, then the courts may never even reach the substantive constitutional issue at all, right? And this reflects separation of powers principles. So the Constitution intentionally limits federal judicial power because courts are supposed to resolve disputes, not function as political advisory boards. All right. And this is one reason that constitutional litigation becomes so procedurally complex, because people take people online, for example, they'll ask broad questions like, can the government do this? Right? Well, legal professionals immediately start asking, who was harmed? Is there standing? Is the issue ripe? Is the controversy moot? Like, what court has jurisdiction? And again, it's because those procedural requirements matter enormously when it comes to litigation. Now that we've talked about jurisdiction, generally speaking, we need to look at the structure of the federal courts itself, because understanding that hierarchy is absolutely essential. And one of the biggest mistakes that beginning researchers make is treating all federal court opinions as if they carry the same authority, and they do not, all right? The level of the court issuing the opinion matters the most, right? And honestly, understanding that hierarchy is going to change the way that you read and evaluate the legal authority entirely. And I should say, let me back up. It's not just the level of the court issuing it, but it's also where that court is. So the federal court system is generally divided into three major levels. And at the bottom are the federal district courts. And above them is the United States Court of Appeals. And those are often called circuit courts. And at the very top is the United States Supreme Court. Now, most federal cases are going to begin in district court, and that's where those trial courts are. It means that it's where litigation actually happens, right? You have witnesses testify, evidence is introduced, attorneys are arguing motions, you have a jury that's going to deliberate, you might have, judges that are going to rule on evidentiary objections or, procedural disputes, but when people picture courtroom scenes from television, involving things like, these very dramatic, like cross-examinations and things like that, they're usually imagining the trial court proceedings. Now, sometimes people will assume that trial courts are mainly focused on the law, but trial courts spend a huge amount of time dealing with facts, right? Like what actually happened, which witnesses are credible, was evidence collected properly, did the parties follow procedure? And those factual determinations become extremely important if a case moves into the appellate process later on. Now, federal courts are organized geographically. So, for example, Georgia is divided into the northern, middle, and southern districts. And each district handles federal matters arising within that particular territory, right? Let me back up. So that geographical structure matters because the venue and the jurisdiction are often going to depend heavily on where the events occurred or where the parties themselves are located. Now, above the district courts, again, is the United States Courts of Appeals. And this is where you will often start misunderstanding the litigation process because a lot of people think an appeal is basically like a second trial. And usually it is absolutely not. Appellate courts generally do not hear brand new witnesses, nor do they retry factual disputes simply because someone doesn't like the outcome of a case, right? And instead, appellate courts are going to review whether legal errors occurred during the proceedings. So the appellate judges are asking questions like, was the law interpreted correctly? Did the judge apply the proper legal standard? Were constitutional rights violated? Did procedural mistakes, did they affect the fairness of the trial, right? And that distinction is critically important because appellate courts are primarily focused on legal interpretation rather than factual investigation. And honestly, it's why appellate opinions become so important in legal research. Okay, so trial courts resolve disputes between parties, but appellate courts shape precedent that future courts may be required to follow. The federal appellate court, again, it's divided into circuits, and Georgia falls within the 11th Circuit, along with Florida and Alabama. So that means that 11th Circuit decisions are binding on the federal district within those states. That also becomes important during research. So if you are researching a Fourth Amendment violation issue for a federal court here in Georgia, then an 11th Circuit opinion is going to carry significantly more authority than a 9th Circuit opinion from California, simply because the 11th Circuit opinion... Ooh, I'm so sorry. Hold on. The 11th Circuit opinion is going to directly control the federal courts within Georgia. Now, could that California case still matter? Absolutely. That is what's called persuasive authority. And it can be used, especially if the legal issue is one that is considered unsettled or emerging, right? But persuasive authority is just that. It's different than binding authority. And again, strong legal researchers are going to be able to distinguish between the two. Now, with the U.S. Supreme Court, again, it's at the top of the federal judicial hierarchy. They are very selective when it comes to the cases that they will take. You have thousands of people who ask the court to hear cases every single year, but they only accept a very, very small percentage for review. The Supreme Court is not designed to correct every legal mistake that's happened in America because it would be impossible. Instead, they focus on constitutional interpretation, nationally significant legal questions, conflict between lower courts, major issues involving federal law, things like that. So one of the biggest reasons that the Supreme Court agrees to even hear a case is because lower courts disagree with each other. Okay, so if one federal circuit is interpreting a constitutional issue one way, while another circuit reaches the opposite conclusion, that becomes a problem, right? Suddenly you have federal law, it's functioning differently, and it's depending on where someone lives, geographically speaking. So the Supreme Court can step in and create that national consistency. Again, going back to that layered structure, it's one of the reasons why that hierarchy matters so much. A Supreme Court's constitutional decision is going to carry far greater authority than a district court's opinion from another jurisdiction. A binding court opinion, again, is going to carry greater weight overall than a persuasive authority from outside of the court. So this is why you should never, simply ask, like, did I find a case? It's like, what court decided the case? Is this binding authority? How much weight does this opinion actually carry? That kind of thing. This is an analytical mindset, and it's what separates true legal research from simply just searching for cases that sound helpful. So when you start looking at the federal court structure, you might, sometimes imagine that the cases are kind of automatically traveling very neatly from one court to the next until they eventually arrive to the Supreme Court. But the reality is very few cases ever make it that far. They tend to end long before it gets to that point. But think about the federal court system almost like a pyramid, and at the bottom are the federal district courts. Again, those are the trial courts where the litigation actually begins. And then you have above that are the district courts with the Court of Appeals. And again, they function very differently from the trial courts. Appeals are, again, not opportunities to completely retry a case. They are courts of review where they're going to look at those legal errors and determine whether or not, or I guess they're going to look at potential legal errors, is what I should say, to see if they occurred, during the proceedings. The appellate judges are going to be asking questions like, did that standard get applied correctly? Did this evidence, should it have been admitted? Things like that. And then you have your highest court of the land. All right, so when most people think about the United States Supreme Court, they picture appeals. And, they kind of imagine this constitutional dispute kind of working its way up to the court system until the justices eventually decide whether or not to hear the case. And most of the time, that's exactly how the Supreme Court review works. But the Constitution also gives the Supreme Court a small category of cases where the court is going to function as the very first court to hear the dispute rather than the final reviewing court, and that's called original jurisdiction. These cases are very rare, which is one reason that, they often get overlooked as existing. But constitutionally, they're extremely important because they involve disputes considered significant enough to bypass the lower court process. So one major example is going to include controversies between two or more states. So imagine like Georgia and Florida are becoming involved in a major dispute over water rights, through shared rivers or environmental resources. Neither state would realistically want the other state's court deciding the matter because neutrality becomes a serious concern, right? So the Constitution gives the Supreme Court original jurisdiction over, interstate disputes like that. Now, these cases do become incredibly consequential, right? So water rights, environmental resources, state boundaries, economic interests, they affect millions of people and often billions of dollars, right? So they're huge. Now, original jurisdiction also applies in certain cases involving ambassadors or foreign officials. And again, the idea is that disputes involving sovereign governments and, international diplomacy carry unusual constitutional importance requiring special treatment. One thing that people sometimes misunderstand is assuming that the original jurisdiction means that the Supreme Court suddenly starts functioning like a normal trial court with witnesses, and stuff like that constantly appearing before the justices. And that is not usually the case. In many original jurisdiction matters, the court appoints special masters to gather, evidence, to manage the factual disputes, and even to make recommendations. That process still differs substantially from, ordinary trial litigation. But original jurisdiction does demonstrate something important about the constitutional structure itself, and that is that the Supreme Court is not simply an appellate body. Okay, the Constitution directly grants it certain limited powers to act as the initial forum for these really significant disputes. All right, so the constitutional design reflects concerns about neutrality, federalism, and even national authority. Now, even though the Supreme Court has limited original jurisdiction, the overwhelming majority of their work does involve appellate jurisdiction. This means that the court primarily reviews decisions made by lower courts rather than hearing cases first. And this is the role that most people think of when they think about the Supreme Court. So a dispute starts somewhere in a lower system, maybe in a federal district court or a state Supreme Court or federal court of appeals, whatever. Then one side asks the Supreme Court to review the decision. Now, sometimes people will imagine, parties having an automatic right to Supreme Court review if they disagree with the outcome, and that's just not how it works. The Supreme Court is very highly selective, and you have thousands of parties who ask the court to hear cases every single year, but the court only accepts a very small percentage. And that selectivity is one reason why the Supreme Court decisions carry so much authority. So you have the court that's going to focus on those major constitutional issues, conflicts between lower courts, important federal questions, and even nationally significant legal issues. Now, one thing you should understand is that appellate jurisdiction exists over both federal and certain state court cases, okay? So the Supreme Court can review decisions from the United States Court of Appeals and in some situations the highest courts of individual states. But there is a very important limitation here involving the state court review. And that is that the Supreme Court generally reviews the state court decisions only when a federal question is involved. So that means a constitutional interpretation, a federal statute, a treaty or, federal rights that something's going to have to be brought into this, right? So if you have a purely state law dispute involving interpretation of, say, a state probate issue with no federal, constitutional issue whatsoever, the U.S. Supreme Court would not review that case because federal authority has not been implicated. But if you have a state Supreme Court rule on, say, free speech rights or due process protections or a Fourth Amendment search, then suddenly federal constitutional interpretation becomes central and the Supreme Court can, now review it if they choose to. Another thing that you should understand is that sometimes the Supreme Court receives direct appeals, but it's under very limited circumstances. Certain statutes permit these direct review from special 3-judge federal district courts, particularly in cases involving injunctions and, highly significant constitutional matters. But these situations are very unusual, okay? Most cases are going to reach the Supreme Court through petitions asking the court to exercise discretionary review. And again, the structure is reflecting something about the judicial system itself, and that is that the Supreme Court, again, is not designed to function as an ordinary error correction, court reviewing every single dispute type court, right? Again, it's going to focus on the national legal consistency, that constitutional interpretation, and those federal questions. And so the broader institutional role shapes everything about how the court selects their cases. Now, one of the most important procedural concepts involving Supreme Court review is certiorari. And students will hear the phrase the Supreme Court granted cert constantly in legal news. But a lot of people don't actually fully understand what that means. So a writ of certiorari is essentially an order from the Supreme Court agreeing to review a lower court's decision, right? Certiorari is incredibly important because it reflects the court's discretionary power. Now, the Supreme Court usually chooses, sorry, I had to sneeze. They choose which cases they want to hear. Now, imagine losing a major constitutional case in federal appellate court and filing, and then you go and you file, a petition for certiorari. It doesn't mean that the Supreme Court has to hear your case. It just means that you're asking them to review it. And then the justices get to decide whether or not the issue is significant enough to justify their involvement. And I know it might be one of those questions of what makes the court decide to take that case. And unfortunately, there's no single formula. But again, there's a couple of factors that do commonly matter. And that is again, conflicts between lower courts. So like the 11th Circuit might interpret something very differently than the 5th Circuit, right? Again, we need them to step in because the federal law should not be functioning that differently, geographically speaking. So we need the court to intervene there. The court also looks at, again, those major constitutional questions, any kind of nationally significant issues, any kind of unresolved federal questions, and then cases that are carrying like widespread legal impact. And timing matters too, honestly. Sometimes the court waits to hear legal issues, while they're still developing in lower courts before like stepping in. Another thing that you should understand is that the Supreme Court's decision to grant cert doesn't necessarily mean that the justices agree with the lower court. And that is incredibly important to understand. Granting cert just simply means that they believe that the issue does deserve review. And so the justices can ultimately affirm the lower court. They can reverse it. They can remand it. It can completely reshape the legal doctrine that's involved, right? And that's one reason that the Supreme Court litigation becomes so strategically significant. Once the court grants cert, then the legal issue becomes nationally important immediately. So government agencies and advocacy groups and businesses and scholars and, media organizations, they all begin very closely following the case because the outcome could reshape law nationwide. When it comes to like appellate advocacy, especially at the Supreme Court level, that becomes extraordinarily specialized as well. Supreme Court briefs are very intensely scrutinized. So attorneys have to focus heavily on things like precedent and policy implications and like national legal consequences on top of constitutional interpretation. And this is one reason that the Supreme Court practice itself becomes almost its own specialized legal field, because the court is not simply resolving individual disputes anymore, it's shaping national legal doctrine. Now let's talk about denials of certiorari. People frequently assume that if the Supreme Court refuses to hear a case, then the court must agree with the lower court's decision. And that's not true either. All right, so a denial of cert simply means that they decline to review the case. It does not mean that they approve the lower court's reasoning, that they agree with the outcome, or that they believe that the lower court was correct on even a smidgen of it, right? So understand that distinction. Remember that the Supreme Court receives thousands of petitions every single year, and they only accept a very small number. They just can't hear every single thing. So denials can occur for reasons that are completely unrelated to whether or not the court reached the right result or not. They can deny it because the issue is not fully developed, or the factual record is just messy. Procedural problems exist, or lower courts haven't created a significant conflict, or the court believes that the issue is just not one that is nationally important enough at the moment. Again, timing matters, okay? And again, sometimes the court intentionally waits while more lower courts address an issue before stepping in. So imagine that there's a brand new constitutional question involving AI and deep fake evidence. The Supreme Court can initially decline to review because it wants additional appellate courts to analyze the issue first. So more lower court decisions are going to create much more broad legal analysis, competing interpretations, and more developed reasoning. And that's going to help the Supreme Court later if it eventually decides to intervene. Okay? Now, let's talk about how strategic Supreme Court review can become, though. Because the court is not simply asking, was the lower court wrong? The justices are often asking, is this the right case at the right time to address this issue nationally? And that's a very different question. Okay, so this is where things can get a little more politically charged. Remember that a denial of cert also leaves the lower court decision in place. So while the Supreme Court's refusal to hear a case doesn't necessarily endorse that reasoning, the lower court's ruling will still remain binding within that jurisdiction. So like if we have something in the 11th Court that issues a constitutional ruling and the Supreme Court denies cert, the 11th Court decision is still going to control the federal courts within that circuit. Unless future authority changes that particular law. So that's one reason that lower appellate courts also carry so much practical power. A lot of disputes will effectively end there. And occasionally you might have justices that will write opinions discussing denials of cert. Those can become fascinating because they will reveal concerns about developing legal issues, disagreements among justices, or even some signals about future constitutional battles. You might have a justice that can essentially say, look, I think this issue is really important, but this particular case is just not the right vehicle to do this with. All right. You can have a justice who might warn that lower courts are moving in very problematic directions. All right. Those writings, they're not binding precedent, but they do heavily influence future litigation strategy and legal scholarship, for sure. And one reason that cert denials confuse the public is because people naturally want very clear answers, and they assume that if the Supreme Court refused the case, the issue must be settled, But again, the legal reality is so far more nuanced because it just means that the court's waiting, the issue's developing, the procedural posture's flawed, or the court just lacks interest at that time. And that's it. The uncertainty is part of how constitutional doctrine evolves gradually over time. Now we're going to wrap this up by looking at two state court examples, and this one is for California. This is one of those things where California provides a really great example because its judicial system is both massive and it's influential. Their trial courts are superior courts, and they are courts of general jurisdiction, meaning that they handle a very broad range of disputes involving, criminal law, civil law, whatever. And because California is so heavily populated, the court system's process is enormous enough. It has so many cases every single year. All right. The practical realities of caseload management becomes very visible in large systems like California's. So like judges, attorneys, clerks, court staff, they all operate under a lot of intense pressure to move these cases efficiently. Above the Superior Court are going to be the California Court of Appeals, and those are divided into multiple appellate districts because one does not cut it. It could not manage the volume of litigation that is coming out of that state. And the Court of Appeals is going to review lower court decisions just like the federal appellate courts. Again, these are not for second trials. They're going to focus on, procedural fairness, constitutional analysis, legal interpretation, and just a general application of law. And at the top of that is the California Supreme Court. And this is the final authority regarding California law, unless there is a federal constitutional question that is going to allow the U.S. Supreme Court to review it. Now, California becomes particularly interesting legally because their state often serves as a national trendsetter in certain legal areas like privacy rights and environmental regulation and technology law, consumer rights, and even, employment protections. So that means that their appellate decisions sometimes become highly influential even outside of California itself. So researchers in other jurisdictions might examine California precedent as persuasive authority when they're looking at emerging legal issues. Now, another important thing to remember here is that state court structures reflect state priorities and history. So California's massive population and its economic influence creates different judicial pressures than smaller states experience, okay? So you have large urban court systems that are going to handle things like very massive criminal caseloads. You have complex business litigation, and you have entertainment law disputes, and then technology-related legal questions that are all of these things that are going to be heard regularly. Okay, so the practical environment is going to shape the legal culture significantly. And it's one reason that procedural knowledge becomes incredibly jurisdiction specific sometimes. So, like legal professionals practicing in California, they have to understand those local rules, the filing procedures, the judicial expectations, and the appellate structure that is unique to that specific system. And this is true for every state, okay? Even though you have a judicial hierarchy that follows similar broad principles nationally, the practical operation is still going to vary substantially between jurisdictions. And last but not least, we have California compared to South Dakota. Okay. This is simply because it's a very good visual for understanding how differently the state systems, operate while still following kind of similar foundational principles. So South Dakota, of course, has a much smaller population and a very different judicial structure than California. So at the trial level, South Dakota operates through circuit courts, which function as courts of general jurisdiction. So these courts are going to handle your criminal, your civil, all of that stuff, right? Now, one thing that you should recognize immediately is how population size affects judicial organization. So California requires very extensive appellate districts and like massive court infrastructure simply because of their sheer case volume, right? But South Dakota has a smaller population, which creates very different administrative realities, okay? Doesn't mean that the legal issues are less important or anything like that. It's just that the court system itself is structured differently. Now, above the circuit courts is going to be the South Dakota Supreme Court. And unlike some larger states, South Dakota does not have an intermediate appellate court between like the trial courts and the Supreme Court. So that means that appeals move directly from the trial level to the state Supreme Court rather. And that structural difference significantly affects judicial workload and the appellate practice itself. So intermediate appellate courts often help to absorb a lot of the caseload pressure in larger states. And without that middle layer, the state Supreme Court itself handles the direct appellate review. Now, in smaller states, in those systems, they sometimes create very different practical legal environments. So like in a smaller jurisdiction, attorneys may know judges personally, and that's through like repeated appearances. Local practice culture might become extremely important. Procedural expectations, they may operate more informally in some contexts, right? And in larger systems, it may feel more compartmentalized and bureaucratic. And neither structure is inherently better, so to speak. They just reflect the different population sizes and the legal demands and the administrative needs of those individual states. Okay? Now, comparing California and South Dakota, again, it demonstrates something important about American federalism itself. You have states that possess substantial flexibility in designing their judicial systems as suited to their individual needs. All right, so as long as constitutional requirements are satisfied, then states can structure, trial courts, appellate courts, judicial districts, procedural frameworks in whatever ways that they want. All right. And that flexibility is part of the broader balance between state sovereignty and national constitutional structure. And that's another reason that legal researchers always have to pay attention to jurisdiction, because that court structure is going to affect your procedure and your precedent, your filing requirements, your appellate review, your litigation strategy. It's going to affect it all. All right. So understanding how a court operates is just as important as understanding that substantive law itself. Now, as we wrap up, I want you to recognize that we've really been discussing two major themes throughout this lecture, and that's authority and structure. Who has the authority to hear disputes? What court controls certain issues? How does precedent move through this judicial hierarchy? What happens when these systems overlap, right? Those questions shape almost every area of legal practice, all right? People outside of the legal profession tend to focus heavily on what they perceive this to look like the dramatic courtroom arguments or the constitutional debates. But legal professionals spend an enormous amount of time analyzing jurisdiction and venue and filing rules and authority and all of those things, right? Because procedural mistakes can destroy otherwise very strong cases. So imagine having an excellent legal argument but filing it in the wrong court, or missing judicial requirements entirely, or relying on authority from the wrong appellate system. Those mistakes matter, all right? One last thing I want you to understand also is that the American court system, it reflects the constitutional values that involve federalism, separation of powers, due process, and the limits on the government's authority. So the structure itself is part of the constitutional design itself, okay? Federal courts remain limited initially. States maintain sovereignty intentionally. That appellate hierarchy, it exists intentionally as well. And all of those pieces connect together. And that's one reason that court structure matters so much, because precedent only makes sense when researchers understand that hierarchy. You could have the most beautifully written opinion, but it's going to mean very little if it comes from the wrong jurisdiction, if it lacks binding authority, or it conflicts with some sort of controlling precedent. All right, so strong researchers are going to constantly evaluate, again, where did this authority originate? What level of court issued it? Does the jurisdiction match? And how much weight does it actually carry? All right, and all of this is going to become second nature over time, but just remember and recognize that legal systems are constantly evolving. All right, court structures remain relatively stable itself, but the legal doctrine itself changes continuously through, new precedent, through constitutional interpretation, legislative amendments, and honestly, a lot of this is driven by societal change. So that means that the legal professional never truly stops researching or learning. All right, and that's one reason that people either love or they hate legal work. Because the law is never completely static. There's always going to be a new case. There's always going to be some sort of new constitutional question or some sort of new jurisdictional problem that's emerging. So for people who enjoy strategy and analysis and investigation and intellectual problem solving, then the constant evolution becomes part of what makes legal work fascinating. And again, understanding, court structure is the foundation that's going to allow all of the deeper legal analysis to actually happen correctly in the first place. And that's really it. I'm going to step off my soapbox. Let me know if you have any questions. Bye.